Okay, everybody. My name is Joe Schaefer. I'm the president of the Unemployment Law Project, and we're going to go ahead and get started here. We apologize for a little bit of a delay. We had some audio issues, and we're also going to be joined a few minutes late by our executive director, John Tierpak. So with no further ado, I'd like to go ahead and turn over to Ann Paxton, who's going to give us a little bit of rundown about unemployment insurance, and then as well as some updates as we have been doing each week. Ann?
Yes, thank you, Joe. 1 second, I'm getting my screen share up here. So thank you very much for showing up for our webinar again this week. So we're slightly changing our agenda approach. We're going to go straight into the latest news. Most people have gotten extremely familiar with the rules and the basic changes that have taken place since the COVID crisis came in. And a lot of people are very conversant with state law and with the federal programs. And then I want to talk a little bit about what ULP is doing in terms of policy reform. We've got a couple of initiatives underway, and we have some questions that people have been asking frequently. We'll address those, and then we'll turn it over to the audience, which is where we get, I think, the best questions during the webinar. So the news from the Employment Security Department is that one thing that's significant is since March 8th, the job search requirement has been suspended. So people who are claiming benefits or planning to claim benefits ordinarily would have to show that they've made 3 job searches a week and be able to produce a job search log on request. But that's been suspended because there are so many jobs where employers are not open, employees are not able to get to work, and there's a lot of other reasons due to COVID that people can't operate normally as with businesses. So the job search requirement has been suspended until May 29th. The governor decided to reinstate the job search requirement as of June 21st. So starting next week, those job searches will have to be submitted. For the period between March 8th and June 21st, I believe June 21st, that if you are doing an appeal or the issue of whether you were available and searching for work comes up, you will have to show that during that period, that before that and after that period, you were doing a job search, but during that period, you should not have to show that. So you should be able until the next round of claims to say that you have not been searching for work, and that is should not be an issue. Another significant event that's occurred is the Paycheck Protection Program has been revised and updated and extended. So this was to provide additional money for small businesses, including nonprofits, that as an inducement to keep people on their payroll. But when it was first passed, the PPP program, as it is called, swiftly ran out of money. So they have added, several, about $120 billion more. So those are open. So if people have small businesses, independent contractors, any business operation where you have employees, you can apply for the PPP program through your bank. You have until December 31st to spend the money on the allowable expenses, which are largely payroll, but also include rent and utilities and so on. And then the loan can be forgiven. So they've modified the requirements, so there's more money, and they've modified the requirements so that it's easier to meet them before the end of the year. And the other major news is that about the backlog in ESD. ESD has been holding weekly meetings with labor and with other interested parties to kind of update everyone on what is happening with the primary primary focus of all the complaints is that no one can get through on the telephone, and they can't understand why their claims have been held up. So when the fraud crisis hit a few weeks ago, there were a lot of claims that came under a cloud at the Employment Security Department, and those, because they were those claimants were asked for additional proof of their identity. When that happened, their claim was put on hold, so they stopped getting any payments. But what we're getting now is assurances from ESD that the agency will resolve the cases of claimants that are under adjudication for various reasons, not including identity. And more speedily, they're going to be resolving the cases that involve questions about identification verification. So the goal date now for the ID verification cases is June 19th, the end of this week. And unfortunately, that means that the other cases that were, some of which have been pending for even longer, even before the fraud crisis, there's about 37,000 of those that are going to be taken until at least the end of the month. And many of those people never got any money in the first place. So it's very unfortunate that it's happening this way. Their justification is that it's an easier task to clear out the ID verification. In order to do that, they've contracted to get 100 members of the National Guard, train them very quickly this week to meet the goal of clearing the ID questions on the claims. And they've also asked unions and businesses to help assist the Employment Security Department in kind of bulk clearing of names of people that they're familiar with, that they know have been laid off, that they know are eligible for benefits. Unfortunately, the Employment Security Department has been advising people who have been victims of imposter fraud, which is the major source of the theft of money from the system in the last month or two, that they will receive a notice of overpayment, but they do not have to pay it back, and they should just ignore it. And the Unemployment Law Project has been strenuously opposed to this announcement because of the dangers of ignoring any notice of an overpayment, which is a government document alleging that you owe a debt. So we have been working to try to get some better advice from the Employment Security Department on that. That's one of the issues that we've been pursuing, talking to reporters and trying to get some better approach at ESD. What we would really like to see, rather than asking people to ignore the notice, is that they not send out the overpayment notices. That's what we believe should be happening. So in addition to the overpayments issue, we have, as of June 5th, we became a party in a petition for a writ of mandamus, which is essentially a lawsuit filed with the state Supreme Court against the Employment Security Department. And basically it's a demand that Employment Security meet its duty and responsibility to promptly pay benefits. So that will be pending for a while. At the moment, we're collecting declarations, that is witness statements from people who had experience had problems with receiving their payments on time. So if you would like to get in touch with the ULP to talk about the possibility of submitting a witness statement to help with that, you're welcome to do that. Our ability to help claimants is largely limited to appeals, but we can help in another way if you can help us in another way by submitting a declaration, potentially. We are also exploring some action on a sort of a very troubling anomaly in unemployment law, which is that substitute teachers who work largely hourly, often at a below average wage, do not have contracts guaranteeing their income, guaranteeing their hours, and yet under state law, they cannot receive unemployment benefits over the summer if they receive, quote, reasonable assurance that they're going to have work when they return in the fall. Because that is a practice for school staff with annual contracts and other people, they're really not in the same situation as substitute teachers. So that's something that we've been trying to see if we can meet with the superintendent of public instruction and try to get some resolution, or perhaps a governor's proclamation on that. Second. Just a few of the questions that we've been receiving as a way to get started on our main focus, which is really answering your questions. We wanted to, these are issues that ESD has been asked fairly often by the Washington State Labor Council, which meets weekly with the Employment Security Department to go over the concerns of its members. And the number one question that the unions are receiving is, my employer is requiring a return to work. Do I have to do it if it is not safe due to COVID? So returning to a potentially unsafe work site or a site that threatens not only the safety of the claimant, but possibly a member of the claimant's family. What are the rules on that? According to the Employment Security Department, the rules are somewhat favorable to claimants. If you report on your claim that the work site is not safe, ESD says we consider that a lack of work, and the claimant will get benefits as long as they are otherwise eligible. But the employer does have an opportunity to respond to that. So the employer may object to it, in which case the claim goes to adjudication, which, as you're probably learning, is a very big, in some cases, black hole where claims can get stuck, bogged down and stuck for weeks. But what they would do in adjudication is fact finding. So they would ask, did you as the claimant report your concern to the employer? Did you file a report with Labor and Industry or with OSHA? And then they would contact the employer to provide due process to both parties. They are working with L&I on this, and L&I, Labor and Industries, has specific measures that they require employers to adopt in order to have a safe workplace. Generally, social distancing, frequent and adequate hand washing, routine and additional cleaning and sanitizing, established procedures for sick workers, and employee education on COVID-19 workplace hazards. So when those are in place, there would be less, it would be somewhat harder to get established that there is an unsafe workplace, but that's not to say it's not. There is a slight advantage in terms of what the claimant is saying when they file a claim. ESD says it is developing a checklist, so that will be on the work sites to say to workers, here are ways that questions of safety will be considered. But again, unfortunately, right now, fraud is the priority. So a lot of the ESD adjudicators are working on that, and they're not going to be diverted away to what is a primary concern for a lot of claimants, which is the work site safety. If the employer does not contest a claim, ESD says it will base its determination on the facts presented. So if there's no response from the employer, the claimant's facts as presented would probably lead to approval of the claim about the worksite lack of safety, although that's not automatic. So another frequent question is, can I get benefits if I have childcare difficulties due to COVID? And as most people know by now, there is an exception under the PUA program, Pandemic Unemployment Assistance Program, which is the federal program, which allows people to collect benefits while they have to take care of a child who is unable to go to school or because the child care agency is closed. So that it technically makes the person not available for work. However, that is a named exception under the law. But do you have to return to work when you get a request from the employer, a demand that you return back to work, depends on whether your benefits are regular benefits under the ordinary unemployment insurance program or under the PUA program. Because under regular benefits, childcare difficulties are not an excuse for declining work that is considered suitable. So you would lose your eligibility if you declined a job, if you declined to return to the workplace, citing childcare. However, if you have PUA, you are allowed to, that is an exception from the availability requirements. If you're caring for somebody who is at high risk in the household, or your child has a COVID-related reason for not being at school or able to go to childcare. But if you're on unemployment insurance and you don't have care available in order to return to your job, you would be denied under regular benefits. What kind of identification do I need to submit to verify my identity for the Employment Security Department? So tens of thousands of people have received requests to submit identification. And one early issue was that the advice to submit that by email. And that's been a serious concern because of security issues of sending Social Security information or anything that identification information that should be secure over email. Now they have a method of uploading those documents in addition to the ability to send them by mail. What they accept is you can send a Social Security card, or if you don't have the card available, you can send a receipt from the Social Security Administration proving that you requested a new card. In addition, a passport, birth certificate, military ID, state, federal, or tribal identification, as long as it has the full name and date of birth and a picture. One important proviso is it must be current ID. It cannot be expired. And just two more before we go on to the general questions from you. This is not a particularly frequent question, but it's something that has come up fairly often. That is, a claimant might be considering retiring and working a small number of hours, that just the maximum allowable in order to still qualify to receive Social Security or SSDI payments. You are allowed to have a certain number of hours. And would this person be able to continue collecting benefits? So the basic answer to that is probably not, although it's possible. Social Security and SSDI are not deductible from unemployment benefits. You can receive those. And you can work a certain number of hours, but you cannot restrict your number of hours in order to receive benefits. You must attest that you are available for full-time work and actively seeking full-time work. So the person in this situation would not be able to, quote, retire and still continue receiving benefits. You do not have to search for work under the current guidelines and the current governor's proclamations, at least until next week. But you do have to continue to be available for work for most regular benefits.
I'd like to add something to that, just because these cases can get a little complicated, because there's actually two issues: being able and available for work, but also what income you might be getting if you're getting minimal hours. So if your minimal hours would put you over the amount that would qualify you for unemployment, you won't get unemployment anyway. So that's always a case-by-case thing, because for minimal hours, for some people, that might be a lot of money. So, and then the other issue is in terms of the availability. Yes, it's true. The rule is, what Ann says correct, you must be able and available for full-time work. However, we've seen some cases where they've used rules about suitability to find that the person, for medical reasons, for example, who may not be able to work full-time, is considered
able and available if they're able and available within the number of hours their medical restrictions allow. So this is very complicated, and these are individual cases. So it's good to consider the big picture here, but individuals, again, seeking help and assistance, we should do individual advice, I think.
Right, and you can, so anybody can do a certain amount of work and still receive benefits. But roughly, if you look at the earnings deductions table, which is available on the ESD website, roughly about 75% of that weekly income would be deducted from your benefits. So that's where you're going to have to decide a lot of people have asked how much income they can get before they have zero benefits, which is a very important question under PUA, because if you are making less than zero, then you can't qualify for the PUC, which is the $600 per week. So yeah, it's a very complicated set of issues. And you do have to be careful. And finally, one last question. My 1099 income was not included in when my benefit amount was calculated, and what can I do? So again, this is another question that relates to the difference between regular benefits and benefits under the PUA program. Under regular benefits, you can't use 1099 income. You've never been able to use self-employment income in order to claim those. So they would not, if you submitted it for when you were applying for regular benefits, they would not include it in calculating your benefit amount. Under PUA, however, remember you have to be denied regular benefits in order to qualify for PUA. You can use your 1099. They will use it and calculate your benefit amount using both the 1099 and your wage or salary income. So it's important to be sure where you are in the application process. When ESD set up an application that is supposed to be somewhat seamless, but we've also heard that it has a separate application process, but you do have to first be found ineligible for regular benefits before you can apply for PUA. And that is where you will be able to use your self-employment income. So that is, yes.
Oh, and I would like to add one more thing about the prior question. Using the R word, retiree, can be very confusing to people at Employment Security. I had a hearing recently in which a woman had left a job. She, quote, retired from a job, but for other work. And of course, we all know, like, for example, active military retire, they might be, 30 or 40 years old. So they're retiring from a particular profession, but not intending not to work again. So sometimes when you communicate with ESD, it's better to avoid using that word because it can be misinterpreted if your intent is to keep working.
Okay. Just want to make one mention of a very useful guide to what makes you eligible under PUA versus what lets you be eligible under regular benefits. It's called the eligibility checker. It's available on the ESD website. It's very handy to show the different ways that you can qualify for benefits in this very complicated system that is now in operation. So we wanted to turn it over to questions from the audience. And I don't know, is Joe moderating, or do we?
Joe, are you on?
I am on, but I think Banaz is going to take it.
Okay, great. Manas, take it away.
Thank you.
Happy to. Thank you. Thanks everyone for joining us and for submitting your questions. We have a number of questions about difficulty reaching ESD when they're trying to provide the information that ESD has been seeking. So ESD is asking for identity materials to be uploaded, but accounts are being locked. We have participants who have been on hold and transferred to various people at ESD, and then they get hung up on, or the call ends, their accounts are locked, and they are unable to provide the documents. What are some next steps that these participants can take?
Well, we are also having trouble contacting ESD and getting responses. So I've been recommending that people contact their state legislators. You can go to leg.wa.gov and find what legislative district you're in, email and call your senator and your 2 state representatives, as well as emailing and calling the governor's office, because they're way behind on thousands of claims. The Sheridan Law Firm filed that writ of mandamus with the Supreme Court, and we are assisting them with collecting witness statements or declarations. So if people would like to make a statement to indicate how long they've been waiting, what their problem is, please contact Unemployment Law Project for that.
Thank you, John. If a claimant is on regular unemployment insurance and loses it due to a COVID-related reason, like a lack of childcare, would they automatically be moved to PUA?
I do not know the answer to that. But to be on the safe side, I would recommend reapplying for benefits under PUA. Unfortunately, we can't get through to ESD to get clarification on this, but that's a question we can add to our list for next week's meeting.
Great. What is the maximum amount of money someone can earn but still qualify for benefits?
So that's what we were just talking about, the earnings. You have to look at the earnings deduction chart. It depends on what your weekly benefit is. And if you look on the chart, you will see that if you subtract 75% of what you're bringing in that week, the amount that you have earned, you'll get a rough idea of how close that's going to get you to zero. John, do you want to add in?
Oh, yes. One thing that really was a revelation to me is when they announced the extra $600 per week for people. I was thinking that that total amount would count sort of toward a person's benefit, and then any earnings in that week would be deducted from that total amount. So I will use an example. What if your regular unemployment was $500 a week under regular unemployment, and you qualified for benefits, and you got that extra 600? So your weekly benefit amount would be 1,100. So what if you got a job or just work part-time and you made let's say $200 a week or $250 a week? Well, you know, that's still a lot less than your $500 weekly amount. So you would report that, and they would do the calculation, and you would get the balance of your regular claim plus the 600. But what if your regular unemployment amount was, let's say, 300, and then you made 500 or so? That would kick you out. Basically, you would have what they call excess income, and this has led to some very unfair results for people who actually are getting less money now that they've gone back to work part-time than they did when they were getting the full benefit amount. It's an unfortunate situation. I'm happy that they added the extra 600. I never imagined that would even be possible, but we get a lot of calls from people who are unhappy that now they're back to work. They have actual less income, which is so counter to what the way things should be. You should always be in a better place if you're working rather than receiving unemployment. So it has led to some problems people are having in terms of going back, as well as the safety issues that we're hearing about on a regular basis.
Great, thank you, John. If a claimant's regular UI benefits have run out and they are being notified that they are able to receive PEUC on their account, will PEUC automatically apply to their next claims, or do they need to proactively select it?
I'm not sure how to answer that. That's kind of technical. PEUC would allow them 13 extra weeks of benefits. I've seen on the ESD application site the question, are you applying for PEUC? So I'm assuming that it's not automatic.
And I would concur with that when in doubt, apply, because this unfortunately is a disappointing situation. Early on in the pandemic, I was led to believe that it would be one-stop shopping, one application, and the department would sort out what you're eligible for. Then come April, and we find out there's a new website with PUA, PEUC, one's the 600, one's for Uber drivers, one's for extension. So when in doubt, apply for everything you may be eligible for. Now, people have asked this question: am I going to get in trouble if I apply for something I'm not eligible for it. No, because if you're providing correct information, there's no problem. I mean, I could apply for unemployment tomorrow, but I have a full-time job. They would ask me what my income is, and I would tell them what my income is for the week. And of course, I would get a notice saying that you were not qualified for a benefit because you made more than the weekly benefit amount. So I wouldn't be in trouble for that. Of course, it would be pointless because I am working, fortunately, but that's why people can keep a claim open if their income is fluctuating week by week. Some weeks they make more money, some weeks hardly anything. Well, if you keep that claim open, one week you report you made $2,000, let's say, you get no benefit for that week. But if your own only maybe $200 or zero the next week, then you would get a full benefit, a full or partial benefit for that week.
Great, thank you. We have a participant who was put on a temporary layoff because her retail employer had closed during COVID. Her employer has now reopened. However, the participant is in a susceptible class, so she has some health concerns returning to work. Her employer has classified her as COVID exception leave because she was high risk. What impact does this have to her unemployment benefits?
She should be able to get benefits. There's a lack of suitable work for her. Going back to work would be a risk. It would be, again, reporting accurately. If there was any work done remotely or anything like that, of course, that would be income that should be reported. But it would fit what the whole program is about. And I think this raises something we've been hearing about a lot, this sort of question, and this happened at the beginning of the pandemic. Well, I am in an essential service, so does that mean I have to work no matter what? Well, you may be in a job that is considered essential, but your individual health issues make it unsuitable for you and unsafe and unhealthy for you. So you should consider that, work with the employer, be in good communication with the employer. Many employers are working with people. I've talked to people who were afraid to talk to their employer, and they got back to me to say their employer just wants them back, but when it's safe in the future and they have this relationship, that they will continue on leave, keep claiming, and it doesn't prevent a person from there's so many different jobs. It's hard to classify everyone, but there are people who can't do a service job, for example, where you're having close contact with people, but they might be able to do a remote customer service job with telecommuting, for example. People have different skills. There's many different jobs. But as we know, many professions cannot be done remotely. Although I have to tell you this, I was taken by surprise because I was speaking with a nurse, and I was assuming when I picture a nurse, I picture somebody working directly with patients, and we were talking. And it turned out this particular nurse, because of her skills and work history, does consulting and is working and is able to work remotely and has worked remotely in the past. So even a job that might appear to be in-person, hands-on, may have opportunities.
Great, thank you, John. We have a question, and I have responded to her directly, providing my email address so that she could potentially submit a declaration. Her question is, after receiving no benefits for 3 months, she has considerable damages, such as her credit being affected. How can she pursue relief from the damage that ESD has caused by their negligence in withholding payments? So aside from potentially submitting a declaration, is there anything else she can do?
Well, people have the right to individually pursue their own lawsuits and claims. It's something the Unemployment Law Project doesn't do, because our mission has always been to represent people in the administrative appeal process. The Sheridan Law Firm is working on that writ to compel employment security to process claims and make payments. So I would suggest contacting your local bar association and try to get some referrals about an attorney or a law firm that would handle negligence cases. I don't know, I can't speak for anyone, but I know there's an organization called Washington Employment Lawyers Association, which is an association of employee side attorneys in Washington State. I could put their website in the chat and just, contact. I think this is something that people should pursue, because I've been hearing many people talk about the harms that have come out of the negligence of the Employment Security Department.
And that website is WELAWEB, wheelerweb.org.
I will put this in the site.
Great, thank you. We have a participant who has been paid benefits for March and April, have been submitting all their weekly claims, and had no issues until they were recently classified as disqualified, and now they're being notified they're in adjudication. What does it mean, and how long will they be there?
So adjudication is, as I mentioned, the area where claims go when there's a question that comes up. For example, you say you made X at a certain employer, they can't find that employer's name in their records, or the employer has one story about your record of employment with them and you have another. Those are, the adjudicators are the ones who resolve those questions. Under ideal circumstances, the Department of Labor recommends that asks states that they have at least 87% of cases in adjudication resolved within 21 days. That's been far exceeded under the current circumstances. And that's one of the reasons that we're pursuing this petition for writ of mandamus. So we can't give any kind of deadlines. What they're hoping, ideally, what they're hoping now is something more like on the range of 4 to 6 weeks in adjudication. They have said there's about 37,000 claims that are relating to identification verification, and there's another 40,000 relating to a range of other issues that were already in adjudication. So we can't say when those are going to be fixed, and you'll just have to keep trying with ESD. That's really all we can say is keep calling. Although actually, I shouldn't say that, because they say do not call us about not getting any payment. But Don, what can you recommend?
Well, it's so hard. I mean, I think people should pursue whatever avenues they can, whether it's individual advocacy, just getting assistance from others. I mean, I've heard different things have worked, so
Very frustrating.
I think a multi-faceted approach can be helpful.
Excellent, thank you. We have a participant who returned to work full-time this morning. However, the last 2 weeks, she has not yet been paid her weekly benefits due to the verification of identity, although she has submitted her requested documents. Any idea on any next steps for her?
Well, again, she's one of thousands and thousands of people stuck in this. She will be paid eventually, but again, it's a question of getting it processed. So I urge contacting the governor's office and your state senator and state representatives who serve in Olympia. A lot of people have told me I've already contacted, like Pramila Jayapal. She's the federal representative. So that's good, of course, because everyone needs to know about this problem with the unemployment system. But I would suggest going to that website, leg.wa.gov. I will put it in the chat, and find your state senator and your state representatives.
ESD has said the goal, and this is not a guarantee, but the goal is to have all of the ID issues resolved by June 19th, and to have all the other cases that are in adjudication for other reasons done by the end of June.
Well, that would be fantastic, Anne.
I've been hearing back from some of the state senators and representatives because people have contacted them. And if you get the right one with the enthusiastic staff member who really wants to serve the people of the state, you will get some action, or at least a really good, sincere effort. Many of our state legislators who have trusted employment security really haven't known how bad the situation is. And this contacting them is good for two reasons. Number one, of course, it may help you get your claim resolved as quickly as possible. But also it lets them know that they need to fund more people to run the program. And this is true even during periods of low unemployment. Unemployment systems all around the country have been understaffed and underfunded for various reasons. I don't want to get into right now, but it's based on populations and unemployment rates and all this outdated data. Like, for example, they will, allot each state how much administrative thing based on population and unemployment rates. Well, as we've seen this year, unemployment rates change, so those numbers are no good. So the state needs to step up and provide more funding and not just bring in the National Guard volunteers. I mean, this is something that should be done on a systematic basis, not on a crisis reaction. And if the National Guard was available in March and April, why were they not called then?
Excellent. Thank you, John. We have a participant who opened up a claim, believes that ESD was using misinformation in calculating their previous wage and income, and the concern is that the claimant is receiving an underpayment and is potentially entitled to more money. Do they cancel the current claim and file a new one, or what would you advise on rectifying the situation?
Well, during normal circumstances, a person, when they file for unemployment, would get a notice indicating what their weekly benefit amount will be, if the claim is approved, and what wages and hours or information was relied on. And included in those documents is information about requesting like a re-evaluation of it. It's not a hearing with a judge. It's just more like, if you think that this information may not be correct, contact us with that information. And it's a way to avoid it, going to a hearing and the big process when maybe when the employer reported the hours, they just left off a few of the pay stubs. I mean, there are honest mistakes that are made all the time that can be corrected. So during normal times, that works pretty well because the person would be able to deliver the updated information. They would look at it, and if they accept it, great. If they disagree with it or something like that, then the person could request a hearing and get it dealt with. And we've seen this over the years with cases. We've had hearings, we've had employers who underpaid people, or they paid some people partially in cash, and partially by paycheck, and then of course things don't match, and that needs to be sorted out. So that's during normal periods of unemployment. Right now, the big problem is access. So people who have told me they've updated and uploaded, that was the word I was looking for, uploaded additional documents like new pay stubs or other income verification, have said they are just waiting now for months or weeks or months. So the problem right now is that if you request a hearing, your hearing request may be rejected because you haven't officially been denied, or there's not a determination that would allow you to get a hearing. And I know this sounds crazy to people listening out there, like, well, of course you are being denied, because if you're not getting a weekly payment, you are being denied. Well, I don't know why this is, but the normal, denial letters that would go out with your hearing rights attached, so you can get a hearing in a couple of weeks, are not being done in some cases and in many cases. So it puts people in this awkward situation. So again, I keep going back to contacting your state senator and your state representatives and email them and tell your story. I think that people sometimes feel that this is sometimes going to some kind of extreme, but I talk to people every day who are at risk of being evicted, people who have families and need money for food and car payments. I talked to a man whose car is about to be repossessed, and he's trying to work with a finance company on that. So calling, bothering, the word bother comes up. I don't want to bother them. Bothering your state senator or state representatives, well, it's not bothering, it's their job to make sure that the citizens and residents of Washington State are served properly by government services that should be running effectively and efficiently.
Thank you, John. We have a participant who has been filing a claim on a disqualified UI weekly claim, but also has an active PUA claim for 2 weeks in April. This participant has not received any payment for over 3 months. Do you have any recommendations?
Again, a all too common problem. If they could talk to someone, it could get sorted out. It's hard to tell what the basis of the disqualification is. But by law, a person who's being disqualified from any government benefit should be given prompt notice of the reason and the right to appeal. Just seeing the word disqualified is not enough, or pending, or in adjudication, or all these other terms we're hearing is not enough. Again, contact your state senator, your state representatives, but again, people can contact the Unemployment Law Project as well and see if we can give any further advice. But in general, keep claiming, keep that claim open, and also try calling that 800 number, because if the National Guard gets trained in 3 days, we can maybe get a few more claims processed.
Great, thank you, John. Regarding substitute teachers, which Anne touched upon earlier, we have some information from a participant who said that Superintendent Reichdahl is anticipated to come out with his guidelines, but not until July 9th. And if subs who are receiving unemployment are sent a letter, usually around the end of June, their unemployment benefits could be impacted. So there's a request that the Unemployment Law Project do move forward with seeking a proclamation from the governor's office for more immediate and effective action. Just an FYI.
Yes. And this has been a very troubling issue for years. The whole idea behind the regional affairs rules makes sense if you're a full-time professor at University of Washington or a full-time teacher in a Spokane school district, and you have a good salary. Of course, educators are underpaid, but at least you have a reliable year-round salary. But substitutes fall into this category of you're somehow given the worst of both worlds. You're given low pay, intermittent work, and then you don't get unemployment when you are not working in the spring break and summer break and winter break. It's a really absurd situation. I'll put this out in general as advice, and this is advice I've been giving for years. If you are a substitute teacher or a community college instructor, file for unemployment during the summer. And sometimes these cases may win in a hearing, sometimes they don't. So advice to individuals should be keep applying for those benefits, and if you're denied, request a hearing.
I just want to add one thing. There's many reasons you can be denied regular benefits, but there's really only 4 reasons 4 or 5 reasons you can be denied benefits under PUA. So I don't want to create false hopes here, but if you're out of work due to a reason not related to COVID, if you're able to work remotely with pay for your normal hours, if you're receiving paid sick leave or other paid leave benefits, if you qualify for regular benefits, or if you quit work without good cause in order to obtain benefits, which is considered fraud. Those are the reasons you can't get PUA. That's all. The list, the reasons you can't get regular benefits is like 3 pages long. So I'm really hopeful that PUA will provide some access to benefits for substitute teachers, but we're not going to wait to find out. We're trying to pursue some action there.
Thank you, Ann and John. We have one final question in our queue. Job search requirements will be mandatory as of next week. What is the option for a high-risk individual who has a doctor's note? Do they need to search for jobs, or should they be responding to the weekly claims differently, and what should they be?
My advice is very straight and simple. Do a job search by email or other electronic means, or even mail resumes, all that, but only look for work that is suitable for you. And I think that is something that will be able to fulfill the job search requirement and keep you on benefits while not endangering your health or safety.
Okay. Thank you. And we actually did have another question pop up. We have a participant who typically works in self-employment over the summer. She is a substitute teacher. How does she get transferred to PUA to make sure her coverage continues?
It's, again, the system's complicated. If you had individual caseworkers working on this, maybe a caseworker did that, but now we have a big heartless computer processing the claim. So I would urge them just to apply for the PUA and give accurate information right now. And if they can't get through or don't get a response, contact their state senator and their 2 state representatives.
But you do need to either be denied or get an indication on the application that you're not eligible for regular benefits. So if you haven't applied for regular benefits, even though you know you might not be eligible, that would be a good thing to do first, and then apply for PUA.
And this is good advice for all substitutes and community college instructors as well.
Great. We have a participant who would like to know how she can work for ESD to provide some relief and make progress on the results. Any advice other than checking out their website to see how she can?
I don't know. Yeah, their advice. Their website should have some information.
Lots of openings.
Applications. Yeah. All right. I must go. I have another meeting I have to get to. Thank you.
Thank you. Thanks, Ben.
Thanks, Ann.